I want to answer a couple of questions I've gotten in the last few days about the Equal Rights Amendment. In the last week, as President Biden's term was winding down, he announced that he considers the Equal Rights Amendment to be the 28th and newest amendment to the United States Constitution. He claims that he joins the majority of legal scholars who believe that it is an amendment to the Constitution properly ratified. Spoiler alert, that's not correct, and we'll talk about why. A quick refresher course, though, on how the amendment to the Constitution process works. Article 5 of the United States Constitution provides how it can be amended, and the primary way that we've used all throughout the years has been that Congress has to vote both chambers 2/3 majority for an amendment. So the House and the Senate have to both 2/3 majority agree to an amendment, which is then proposed to the states. The states then vote by a 3/4 majority to approve it. This means that the legislatures of 3/4 of the states have to follow Congress and say, yes, we want this to be part of the Constitution. And at that point, it is considered ratified. Note that the president doesn't really have any part in this process. So this amendment that he's referring to, there are 27 amendments currently to the United States Constitution. This amendment was first proposed in the 1970s, and there was a deadline set of 7 years to have it ratified by 1979. It was proposed by Congress, by 2/3 of the House and Senate, who said we would like it to be proposed to the states, but they put a 7-year deadline. Now there's no deadline process in the Constitution itself. Actually, the 27th Amendment sat around for over 100 years before it was ratified. There are others that have lingered on for a long time, but sometimes for political reasons, when proposing it, part of the compromise has been in Congress put a limit on it. It's actually started with Prohibition. The Prohibition Amendments were the first. They set a deadline and said if we don't do this within 7 years, it's dead. And no one's ever challenged that that's something that Congress can do. So Congress, in voting on it and presenting it to the states, put a 7-year deadline and said if it's not approved by then, it's dead. Well, 1979 came. They didn't have the 3/4 majority, which is 38 states that they needed. And so Congress, by a simple majority, meaning just a bare majority, voted in both houses to extend the deadline. So as an initial matter, most scholars agree that's not effectual. You can't extend the deadline because once Congress has prompted the amendment, the states either accept or reject it. Imagine, in other words, if Congress halfway through the process said, actually, we're going to change the amendment. We're going to shift it completely and then try to change it. Well, they extended the deadline, and then 3 years later, that one expired, and they still didn't have the majority that were needed. But states, for various reasons all throughout, have taken votes on the Equal Rights Amendment for the decades that have followed, and in 2020, Virginia theoretically became the 38th state. There may be a problem with the counting, too, because some states, in the meantime, have unvoted on the Equal Rights Amendment. So it's unclear what that would mean for the Equal Rights Amendment. So what is the Equal Rights Amendment? It is an amendment that purports to treat men and women equally under the Constitution. And while many people feel, what could be wrong with that, there's been a lot of debate about what that would actually mean, whether that would abolish our current rules regarding the draft for the military, whether it would create other barriers to sort of gender-based disparity employment that the federal government has put forward to help women get ahead. There are a lot of different views on the Equal Rights Amendment. Without getting into whether it's a good idea or a bad idea, what's absolutely clear is that it has been dead in the water for decades. It's not just my opinion. Justice Ginsburg had that opinion. A number of really important leading lights in constitutional thought have had that opinion. So President Biden's decision all of a sudden to come out several years after Virginia had purported to ratify it and try to say, oh, I think it's ratified and I hereby, believe it is, really doesn't have any legal significance. It's unclear what prompted this. There had been a big push for it. Maybe this is just to try to get people to start talking about it again, in which case I guess it worked. Here we are. We're talking about it. But it seems very clear that at this point, nothing in the Constitution will change in regards to that amendment. This brings us to the question of how we propose amendments. I think amendments to the Constitution are really important. They're the way that we keep our government fresh, so I think it's good for us to talk about them. But the constitutional process is designed to make sure that we have a consensus, an overwhelming majority in favor of making changes to our governing document, and that overwhelming majority was ready and present all at the same time. It's not something that happens slowly over years, but something that happens all at the same time. So I hope that answers some of your questions about this newest wrinkle in constitutional law.